A recent High Court decision provides useful clarity on expert determination and the role of the courts. The key point is straightforward. Where the parties have agreed to resolve disputes by expert determination, they will generally be expected to follow that process. The courts will be slow to intervene, particularly before the expert has made a decision. This case concerned a dispute over an earn-out following the sale of a food truck manufacturing business. The difference between the parties was significant, approximately €220,000 as against €2.2 million. Under the share purchase agreement, the dispute was to be referred to an independent accounting expert. However, before that process began, one party applied to the court seeking guidance on how the expert should approach the issue. Relying on the Supreme Court decision in Dunn Stores v. McCann, Mr. Justice Toomey confirmed that the court intervention in advance of an expert determination will only arise in exceptional circumstances. He described the application here as premature and unnecessary. Importantly, the court also made clear that interpreting the relevant provisions of the agreement was part of the expert's role. That was a matter the expert was entitled to decide in carrying out her functions. The application was also premature in a practical sense. Depending on how the expert approached the issue, there may have been no need for any court involvement at all. The judgment also highlights some important considerations. Where parties appoint an expert, particularly in a technical area, that expert must be allowed to carry out their functions. Early recourse to the courts increases costs and delay and undermines the very purpose of expert determination as an efficient alternative to litigation. The takeaway is clear. Parties should adhere to the dispute resolution mechanism they have agreed. The expert process should be allowed to run its course. Any challenge, if it arises, should be considered only after the expert has reached their determination.